Sessions. I'm Gwendolyn Sterk of Sterk Family Law Group, and I'm honored and privileged to have my dear friend Seth Matus with us today from Workplace Law Partners. Hi, Seth. How are you today?
Good, Gwen. How are you?
Great. Well, I'm kind of excited today because we're going to learn about new laws that are going to affect both employers and employees in 2025. And there's a numerous um, collection of these laws. And as a result, we're going to do this as a part one and a part two, if you don't mind, Seth, because I think there's a lot to cover. Would you agree?
I do, Gwen. Every year, the Illinois State Legislature gets very busy, and they really have rolled out a whole series of laws that are going to be fairly big changes for both employers and employees.
Well, let's get started on this. So, first of all, we have some amendments to the Illinois Equal Pay Act. Tell us about that.
So, the basic thing with the Equal Pay Act is they are trying to address the issue of pay inequity and then pay transparency. I mean, so in the past, there's been a lot of media attention on sort of women are paid less than men, minorities are paid less than, Caucasians. And so they want to try to do some action to prevent that from happening. So, effective on January 1 of 2025, the Equal Pay Act is going to be amended. And basically, what it is doing is any time that you have an employer which has at least 15 employees, whenever it has a job posting, it is going to need to, number one, list a pay scale of what is, going to be offered for anyone who applies for the position, and two, talk about what the benefits are. So that needs to actually be in the job post. The second part of what's happening with that law is that if the employer's job posting is intended for outside candidates, within 14 days after you put up the posting, you need to let your existing employees know about it and give them the same information so they have an opportunity to apply for the job too.
Wow, that's a lot. So,
Yeah.
I read an article about this and somebody said, so, you give a range for what you're going to offer for that particular position. But what if you put something really low out to something really outrageous for a job? Let's just give a range that the salary range is 20,000, depending on experience, up to 200,000. Wouldn't that kind of defeat the purpose of what they're trying to accomplish?
Gwen, it would. And so the Illinois Department of Labor has been rolling out a bunch of guidance in terms of what's permissible. And it really needs to be something that is the good faith estimate. And so, part of what the Department of Labor is requiring is for the employers to keep records showing how did you come up with this? And so if you had that kind of really broad range, which was obviously, trying to defeat the purpose, you could get in trouble if you end up getting audited.
Understand, but let's say that there's another opportunity that comes up and you offered a job and it paid between 40 and 75, but
Yeah.
you're the employer and a great candidate came through and said, I'm currently at the top end of my scale, so I want 10,000 more. I'm not going to take the job. Can you offer it to them or what do you have to do to open that position? Because you really want that person.
So that's an interesting situation. And you're right, Gwen. In that situation, there would be an exception. If this is sort of like a stellar candidate and you want to have that person, just so long as it's documented that this is why you did, you went above, you're fine. That would be something that would be permitted under this law. It's not meant to sort of like defeat that from happening. It's just sort of that you are trying to make the process a little more transparent.
And but what if you went 25,000 higher or 50% higher than it is? I
Yeah.
understand that it appears to me to be reasonable because I really want this candidate. They're computer savvy, that technology is such a big deal that you really want to pay that price. But do you have to be worried about it as an employer?
I would think that, it depends on how much beyond your pay scale you go. I
Okay.
mean, yes, you're right. I mean, there is some tension. Let's say that you're talking about, your anticipated pay scale is starting from 25 to $35 an hour. And then you get the person you're describing, you're paying this person 65 an hour.
Right.
Uh, yeah, the further and further you go, the more tension there is going to be. And so, I'm not saying never, it's totally prohibited, but you need to make really, really sure that you keep records showing
Okay.
why you did that. Then you'll probably be okay.
And what if you're taking an applicant for this particular position and you see that they really could do maybe two roles in one? They have the skill set. I'm always a believer that not everybody can do everything, but you find a candidate that comes in and they're like, they blow you off your feet, so to speak, and you're like, wow, can you create a new position for that person and then not advertise that position? Or do you have to go back to the drawing board?
No, actually, that's another interesting question, another interesting point. You do not need to go back to the drawing board. And one of the things that the Department of Labor has said is that, it is not a requirement that employers actually provide a job posting. Let's say you just want to go through the grapevine and see what's out there and you get a candidate like that. You don't have to actually have a posting of that. You can just hire that person. And, similarly, if you just have a company, let's say a store, and you just post up a help wanted sign. If it is not a specific position that you're advertising, it is not required that you go out and actually do all the obligations of this law.
And what about your requirements to the existing employees? Because obviously you talked about the second part. So you get this
So,
unbelievable candidate you meet and you want to hire him for a new position. Do you have to tell your existing about that?
well, if there is a job posting, you do. But you don't have to offer those jobs to the people. It's only you need to let them know what it is. You need to let them apply. But then if what ends up happening is you get the stellar candidate and that's who you choose, that's your prerogative, not implicating this law.
So it's going to be really a tough call and really one where getting a good employment lawyer involved to answer some of these questions might be important, right? To cover yourself.
I I think that this is a law that could potentially cause a lot of problems to employers, especially if you're not familiar with it. So yes.
Is this type of coverage available through your employment practices insurance?
Uh, it's an interesting. I think that what I would recommend that you do is you talk to your insurance broker if you have an EPLI policy, and
Right.
they probably could give you guidance on it. I mean, it seems like this is the kind of coverage that should be there. But one thing I've also observed with a lot of insurance products is they don't necessarily keep up with the law, and especially with a state like Illinois where it's changing literally year by year.
Yearly. I mean, we're having these
Yeah.
meetings regularly. Well,
Yeah.
that's an interesting new change. The next law we want to talk about today is the Illinois Wage Payment and Collection Act. It has some amendments. Tell us about that.
So the Wage Payment and Collection Act generally protects employees' rights to be paid, like it sounds. And so that is the Illinois law, which basically, say vacation time mandates that if vacation is being offered, you need to provide it. The change this year, which is, coming into force, talks about pay stubs. And it's a very narrow, but what it is basically saying is that every employer, regardless of what you've done in the past, starting on January 1 of 2025, needs to offer some type of pay stub, whether it's a paper stub or electronic, but it needs to list, regular rate of pay, overtime rate of pay. If it's a non-exempt employee, you need to list the hours worked. You need to list the total gross compensation. You need to list any deductions taken out of it. And then you need to talk about both, year to date, both for pay and then for deductions.
Interesting.
Going beyond that,
Uh-huh.
that's only the first part. Um, Basically, it also gives both existing and former employees a right to see their prior pay stubs. So they can come back to you. Um, what they basically say is if it's a former employee, it's a year from termination. If it is an existing employee, it could be anywhere up to 3 years from the date of the request. And as
Interesting.
an employer, you would have to give them all of their prior pay stubs.
Wow, that's a lot of information. Now, does this
Yep.
apply to any size employer or is this 15 and more like the other law?
No, this is any size employer.
Wow.
So this will really go across the board. And so,
I mean, you think about
yeah,
companies that have hundreds of people that might just be summer help. They're going to be obligated under this as well, right?
correct,
Wow.
correct. Yeah, this could really, I mean, again, and then you also think about the mom and pop shops
Sure.
or places with just one or two employees. This is now a requirement. So people just need to be aware of that.
Interesting. And, we talk about Illinois for these last two laws. Is this a common practice that you're seeing in other states as well, or is this really something that is expanded in Illinois, particular?
I think that what you can say is a general rule. I mean, it is Illinois, and it would be sort of like the states that you might expect. I mean, on either coast. So, I mean, I think that you see similar laws in California, in Washington State, Oregon, anywhere up and down from, say, Maryland all the way up to Maine, and then maybe places like Minnesota and Colorado. Um,
Understand. So
Other states, I mean, like, go to Indiana, Iowa, you're not going to see this.
you're not going to see it. It's very interesting. And I think that's kind of, people often wonder that. Is this for everybody or just for us? Should we, you know,
Yeah,
operate in both states? Should we move? All these questions come to people's minds, I think, when they hear about these law changes. Now, the
right,
next one we want to talk about today is the Illinois Human Rights Act. That also had some amendments to it. So tell us about that.
right. And so the Illinois Human Rights Act is Illinois' discrimination statute. That's the one that prohibits any kind of race discrimination, age discrimination, etc. So what the Human Rights Act did is provide two new categories, which are now going to be protected. So the first protected category would be family obligations, family responsibilities, excuse me. And basically, what that would be is let's suppose you have a need to care for a parent or a grandparent, a child, a brother or sister. Um, if you have those obligations and you tell the employer that you need to take care of them, the employer cannot discriminate against you because of that. And so it's kind of an interesting issue because, certainly there's been laws, say, like the Family Medical Leave Act,
Yeah.
which allowed people in the past to take time off. Um, this law doesn't, the Family Medical Leave Act only applied to 50 employers, employers that had at least 50 employees.
Right.
This one would be applicable to any size employer, but it doesn't really further define what that means to discriminate against someone. I think that probably what I'd recommend with that one is that certainly if an employer is letting employees have time off for, let's say, a health problem, they be allowed the same time off to care for a family member. That's probably how I see that one playing out.
Well,
But
now let's
uh,
just say that you have so much time for sick time and vacation time. Your time off for a smaller company to care for a loved one, really, if once you're gone with your sick day and your vacation day, is there an obligation to extend that open?
well, that's going to be the open question about what
Right.
this means.
Yeah.
Yes, yes.
And
So,
how far does that go? So, for example, you hire somebody to do a job and they say, well, I can only work 30 hours a week for the next 3 weeks because I've got caregiving responsibilities for a parent. And that job is no longer getting performed. So, do you have to go out and hire a second person to fill in, or can you replace that person because that job isn't getting done? I mean, these are, it's a serious balance. I understand people have life issues, but also there's a business to run, right?
I think you're exactly right, Gwen. And so this has not yet been defined. We don't really know how far this is going to go. All we can do is we can sort of look at what have courts done in the past when it comes to other categories. And basically what they provided is that, well, no, I mean, if a person simply can't do the job, because of whatever, a medical reason, something like that, you don't have to keep the job open for them. On the other hand, if they're able to do some degree of the work, I mean, then it starts to become an issue. And you have this possibility. And I would suspect that what's going to happen with this type of category, this new protected category, is something very similar. So that's category number one.
Right.
Yeah, that's category number one. Category number two are called reproductive health decision.
Okay.
Reproductive health decisions would include anything like seeking abortion, in vitro fertilization, any kind of sterilization, any type of action which a person chooses to take also is now a protected category. And so, what the Human Rights Act talks about would be, let's suppose a person needs to have time off because they're going through a round of in vitro fertilization. They should be given time off for that. A person is recovering from giving birth or from an abortion. I mean, they need to be given time for that.
And does
That's
it have to be paid time?
no, no. If it is not time, if you don't provide paid time off for other kinds of absences, you don't have to. But if you are, you can't single out this type of absence and say you're not getting paid.
Understand. These are really interesting issues because it really leaves that employer in a state of flux, meaning that
Yeah,
I feel that, just having my own business and hearing from other business owners that situations arise that now they view it differently, meaning that they have to like stop and think about it. What does it mean? Does somebody have rights in this category? And it's very difficult because, I'm an attorney, so it's a little easier for me to navigate compared to somebody who has no legal background. But even myself, I wouldn't know where to go with these different legal issues. So that's why I think it's important to have an employment lawyer on speed dial, so to speak. Wouldn't you agree?
I think so, Glenn. I mean, it's a sliding scale. Every year, you can't quite say what is permitted, what isn't permitted. Um, and that's just one of the features that's happened in Illinois, and employees really need to watch out for.
Right. So really reaching out. And what about an amendment given all these new law changes to the employee manuals? Is that something that employers should be looking out for?
And that's also something which, employers, especially if there's other issues that need to happen in their handbooks, yeah, it is something which should be updated,
Got it.
just so that you are keeping entirely in coordination with the law, entirely consistent with the law.
And I do think that it is thinking differently about these issues, that you can't operate in a vacuum just from your own window pane, looking out and saying, well, that's going to affect my business. Now we have to look back and see what the law is going to be and how that affects the employee. And sometimes not knowing, and that not knowing should give you the impetus to place the call to get assistance. So,
Right. I mean, I think that people generally have an idea of what discrimination is. I mean, you think of race, you think of age, you think of sex.
right,
Some of these categories, when you get beyond that, aren't so obvious.
right,
You
right,
don't think about that. And
right.
so that's what I think gets really difficult for employers.
Sure. Well, if you have questions about this, if you are an employee or an employer, Seth is a good person to reach out with and have these questions answered and get it addressed. We appreciate your time on these updates. I know that some people feel very overwhelmed by this, but it's helpful for us to have you kind of untangle this web, so to speak. So thank
Always. And great talking to you, Gwen. Certainly, if any of your listeners ever have any questions, they can reach out to me and I'll try to answer the questions to the best of my ability.
very good. Seth's contact information will be available, and thanks for your time today.
Thank you very much.